Thursday, September 2nd, 2021.
Unprecedented. That's the word Rachel and I were discussing at the beginning of this hour, and that's the word that appears repeatedly in the dissenting opinions from the 4 Supreme Court justices who believe that the new Texas abortion law should be stopped in its tracks. Unprecedented is a very strong word for judges, but it has lost its meaning in public discourse, especially in the age of Trump. Justice Sonia Sotomayor just couldn't take it anymore. She just couldn't go along with the semantic decorum of the court and use such understated language as unprecedented. And as Rachel pointed out earlier, the first sentence in her dissent is, "The court's order is stunning." And she goes on from there, quote, "The extraordinary step of enlisting private citizens to do what the state could not. The Texas legislature has deputized the state's citizens as bounty hunters, offering them cash prizes for civilly prosecuting their neighbors' medical procedures." She then calls them, quote, "citizen bounty hunters," a breathtaking act of defiance of the Constitution. This is untenable. It cannot be the case that a state can evade federal judicial scrutiny by outsourcing the enforcement of unconstitutional laws to its citizenry. Justice Sotomayor ended with what, for the court, is a version of pounding the table in anger. Her last sentence is simply, "I dissent," instead of the traditional, "I respectfully dissent." And joining us now is Prof Tribe, University Professor of Constitutional Law Emeritus at Harvard Law School. He has won 35 cases in the United States Supreme Court. His new article for The Guardian is entitled "Roe v. Wade Died with Barely a Whimper," but that's not all. Professor Tribe, thank you very much for joining us tonight, and I want to give you an open field here to comment in any way you want on this decision and let America know what they should be thinking about it. The one thing I would ask is that you begin with Judge Sotomayor's point about this peculiar deputizing of the citizenry to be the civil prosecutors of actions that have no relationship to them whatsoever. It establishes a class of plaintiffs that have never existed in American law that I'm aware of. This Texas law seems to have no relationship to American law, federal or state law, in saying that it will be citizens who enforce this law, not the law enforcers of the state. And the Supreme Court used that, apparently, as the reason why they couldn't stop it.
Well, it is truly stunning. Justice Sotomayor had it exactly right. It's not exactly unprecedented. Back in the early slave years, fugitive slave laws were enforced by bounty hunters. They went out and sought to return even freed slaves to their so-called owners to collect a bounty. So it has a kind of ugly, dark history. But as Justice Sotomayor said, it simply cannot be the case, although 5 justices say they think it is. It cannot be the case that the state can pass a flagrantly unconstitutional law, unconstitutional unless and until Roe v. Wade is formally overturned, and then avoid any judicial review by deputizing strangers, total strangers. And they don't have to be Texans. They can be from California. They can be from France. The law clearly allows anyone on the planet Earth to come into Texas court during, as you say, that 4-year period after an abortion and get $10,000 from anybody, the friend, the neighbor, the ex-lover, the Uber driver, the person who funded the abortion, anybody who was involved in an abortion, unless somehow the evidence is accumulated that there was no heartbeat. That is not only stunning, it's abominable, it's breathtaking. And I'm hopeful that even though we know this court does not believe that Roe v. Wade should stand, that maybe one of the 5 justices in a lawsuit that attacks specifically the bounty hunting aspect by preventing officers of courts from actually transferring the bounties and thereby taking the financial incentive out of it, maybe a justice will be so upset by the idea of privatizing law that we would get a fifth vote. Not at all likely. But there's very little else that can be done. The whole idea of legislating Roe v. Wade, making it part of statutory law, which I've favored for a long time, is something that is going to happen in the House, but it looks like it will die in the Senate. And even if it were passed, a court that just a little while ago in 2007 said that the commerce power of Congress is broad enough so that Congress can ban a particular late-term abortion procedure, they probably will turn around and say, oh, but now we've discovered new limits in the commerce power. They can't do that. Just imagine if we were talking about a right that conservatives like gun rights. Suppose Massachusetts, the state where I live, decided to disregard the Supreme Court's precedents about guns and made it a crime for any private citizen to own a pistol without special government permission and without showing need. Flagrantly unconstitutional. But if they didn't have public prosecutors enforcing it and had like an army of citizen vigilantes making sure that nobody could have a gun at home, do you think this court would have applied its logic to say, oh, that we're going to let that go into effect? Not on your life. So they are not at all consistent. All of these procedural mumbo jumbo things that they said make it very hard for us to figure out how to review this law. That was just really concocted for the purpose of evading review. And what was most stunning in Justice Sotomayor's dissent was how compelling her arguments were. I mean, there was emotion in it, but the logic was impeccable. She said, she could have added to what she said. She could have said, when you deputize private citizens to enforce the law, they become arms of the state. And so you should be able to go after them in the same way you can go after other state officers. But instead, the majority said, well, we're not sure that these judges who were sued are proper defendants. We're not sure you can sue a judge, a state judge. There's nothing in the Constitution that says you cannot have federal suits against state judges. We're not sure that these judges would enforce the law. What, are they going to be scofflaws? It's all made up so that the majority is just tipping its hand. They hate Roe v. Wade. They ducked, didn't want to say that it's overruled. They claim not to be judging that. But in the very same time, they're simply obliterating the rights of all of the women of Texas to control their own lives and their bodies. And I do think it's not clear that they can leave the state without creating vulnerabilities. I mean, if I pay somebody to help them get a bus ticket to go to a neighboring state where she can get an abortion, I might be aiding and abetting an illegal abortion, even though it's not illegal at the state where she goes to. That may not be true, as some have said, it's ambiguous. But as long as the chilling effect is there, as long as you don't know when you're helping a woman deal with a tragic situation in her life, as long as you don't know whether you're going to be sought for $10,000 here and $10,000 there, that you're likely not to reach out and help her as a good Samaritan. So this is a devastating decision. I said in my op-ed piece in The Guardian, welcome to Gilead, the nightmarish place in A Handmaid's Tale. That's the world that this court is creating, and I think it's a disaster.
Harvard Law Professor Lawrence Tribe, thank you for joining us tonight. Professor Tribe's column about this is in The Guardian. It is entitled Roe versus Wade Died with Barely a Whimper, but that's not all. You should read it. Professor Tribe, always a pleasure. Thank you very much for joining us.
Thank you, Lawrence.
Thank you. And coming up, the grand jury in Manhattan heard testimony from 2 key employees of the Trump Organization today as part of its investigation into Donald Trump and his businesses. Tim O'Brien will join us next.